Welcome to the Mac Venable Payments Bootcamp. This is the second panel that we have in our series of 3. Today's session is on navigating high-risk industries. The participants today will be able to receive CLE credit, and we will provide that password during the presentation. I'd also like to remind everyone that our last panel will be tomorrow, 2 p.m. Eastern again, on popular and evolving payments business models. This panel will be moderated by our colleague Evan Mintzberg and features speakers from Incom and MindBody. The panel will explore issues facing popular models amid increased demand and prominence as a result of the pandemic, including marketplaces, merchant of record, and other new payment methods. So with those formalities out of the way, let's go ahead and kick off today's panel. My name is Andrew Biggert. I'm a partner here at Venable, where I work in the payments group. I represent banks and processors, payment facilitators, and other payments companies on regulatory compliance and business transactional issues. I'm joined today by my colleague, Ellen Burge, also part of Venable's payments group. Ellen also works with all types of payments companies on contracts and regulatory compliance, as well as representing them in enforcement actions involving the Federal Trade Commission. She also has significant experience in the advertising and marketing world, where she helps merchants and processors and others understand those issues as well. And finally, we're very excited to have Brian Jones on the panel. Brian is the Senior Vice President and General Counsel and Secretary at Merrick Bank. In this role, Brian counsels bank executives and staff on day-to-day legal matters and corporate governance issues, including with respect to merchant acquiring and other payments-related issues. So in terms of today's discussion, our agenda, we're going to start off kicking it off with discussion of risk and why it's important for the payments industry. We'll then shift to looking at some of the specific high-risk industry verticals and talking about what payments companies should be thinking about in terms of them. And finally, we'll close with a discussion of general risk management and compliance best practices. All right, so what does high risk mean? Why are we talking about this? Well, sponsor banks and payments companies all have various legal and regulatory requirements, which could be the case under the anti-money laundering laws, economic sanctions laws, general consumer protection concepts, et cetera. And these legal requirements are kind of the why, it's important to be focused on high risk, but it's a lot more specific and detailed to that. And it can depend on a number of different variables, depending on whether you're the bank or the processor. But some of the key factors to consider are the higher risk of fraud to the payments network or its participants, and what the card brand rules require and the liabilities that are passed down, the potential risk of financial loss to the acquirer or by contract being pushed down to the processor or others in the payments chain. The higher risk of harm to consumers, which can result in enforcement actions and regulatory scrutiny. Same dealing with illegal items or things that have questionable legality can result in a lot of scrutiny and risk. And of course, there's a reputational damage that can come with an enforcement action or even just significant consumer complaints. So with that, I think I'd like to kick it over to Brian to maybe, at a sponsor bank, Brian, how does a bank think about risk and the kind of the different levels of risk that it's willing to take on? Can you maybe give us some insight into that decision making?
Sure. Like most things, along these lines, it's a lot of sausage making, but I'll try to make it clean and simple. We like all of the participants in the ecosystem. We pay close attention to the card brands and to our regulatory authorities, and so those sorts of rules and guidelines really drive how we think about risk. So you've got that set of them. And then the other part of it is a lot of, just sort of balance sheet management. And, we're going to talk a little bit more later on about reserves and those sorts of things. And so, that there's a big money portion of it that has to do with, the sort of things that we all think about with fraud and chargeback risk and volume limits and those sorts of things. And so we think a lot about that and have a lot of risk management tools in place on the money side. But then it's also the legal and regulatory side as well, where we have regulators examining us every year for safety and soundness and compliance, and we also have visits from card brands and others that care about us making sure that we are doing business properly and in compliance. And so within our team, different people think of those risks in different ways, and so there's a lot of discussion and meetings and committees and things like that we use to get in sync on how we collectively think about risk. But at a high level, that's sort of how it works at Merrick anyway.
That's great. So that's kind of the sponsor bank perspective. But how, Ellen, maybe you could give us some insight. How do regulators view risk, and what's driving their focus?
So I would say it's a pretty different viewpoint that the regulators have. So Brian described a lot of things that have to do with, risk of a business position, risk of financial risk of loss, those types of things, all completely legitimate reasons to be concerned. But the regulators, especially the consumer protection regulators, are going to be worried about the risk of harm to consumers. So sort of that middle bullet point right there. So they're thinking about when you're processing payments, when you're, who are these merchants that you're providing this key service to? And is there something that they will say more insights into things like chargeback reasons that are coming in, the volume of chargebacks. Why are consumers complaining? What are these merchants actually doing? How many websites have they set up, for example, to sell something? Are they engaged in marketing practices that are high risk in themselves because they're some sort of a negative option or a telemarketing program? And so their view of risk is, what are you doing to manage that as a processor? What are you taking a look at? Are you properly underwriting? Are you properly re-underwriting whenever there's red flags coming up? And really, it's pretty much a different world, I would say, on that side of things.
Great. That makes a lot of sense. And I think we can, in this slide, maybe dive in a little bit more into some of those kind of buckets of risk. And we've tried to do that on the slide here. So obviously, financial loss is a big consideration on the business side. And in the payments world, the potential loss can be the full value of the transaction. At least that's the position that the regulators will often take. There are other kind of fines and fees and assessments that can be flowed down from the card brands. And certainly there's a lot of in-house time and expense that goes into managing these types of losses and risks that should be considered as well. On the consumer side, I think you can see things like class action lawsuits. There can be criminal liability if you're knowingly facilitating some kind of unlawful or criminal activity. There can be the loss of the reserves that are set up to manage risk in the first place. And obviously enforcement actions can result as well. And then finally, reputation and operational damage. Your reputation in the industry can be lost. Business partners may have concerns about doing business moving forward if you're not managing your risks appropriately. And in the event of any kind of enforcement action, there can be injunctive relief that kind of boxes in the business moving forward. So these are all key risk variables. Ellen, if we're in the enforcement context and you're dealing with the FTC and you're kind of involved in negotiations, what does that look like, and how do you kind of manage some of these issues during negotiations with like the FTC, for example?
Well, if you find yourself in this position and you're trying to end, frankly, an investigation that could turn into a lawsuit, or maybe has turned into a lawsuit, and you just want to agree to disagree essentially and settle, you're really thinking about the primary things would be money and injunctive relief. And money is one thing, and certainly there's all sorts of ways for a government agency, the FTC and the CFPB, the others, to calculate the dollars that they think should be paid in certain circumstances. But I would really pay attention to the injunctive provisions. These are operating requirements that can really hamstring the business going forward, impose on your business things that other businesses don't have to agree to. And in some cases, there's bans often proposed, so not processing for entire lines of business. In some cases, not processing at all, getting out of the business. And certainly those are things to negotiate. And we've seen some folks just say, look, I'm getting out of payment processing. I'm going to take a ban and move on and do something else. But, even what might seem as a narrowly tailored ban, you have to think about how quickly technology changes and marketplaces change, and bans can really come back to haunt you later. So we're often negotiating what's reasonable. If there's extra monitoring requirements, often one of the things, for example, that gets negotiated are chargeback thresholds that spark some sort of an action to pause and take a look what a merchant's doing, and that threshold will be much lower than you might have otherwise done it if you were just following the card brand requirements. So again, really different types of things, higher standards that you'd want to pay attention to, and make sure you can do something reasonable and doable for your business.
Great. So the next few slides, we actually have some hypothetical scenarios we'll go over and talk through. And these are the type of things that are pulled from real life, but the names have been changed, so to speak. So here's the first one. Your business underwrites and onboards a multi-level marketing company. 6 months later, the FTC gets a court to shut down that merchant with an asset freeze and the appointment of a temporary receiver and a preliminary injunction. You receive letters from the receiver asking for a sworn statement about the merchant accounts that you have for the merchant and how much money is held in reserves, et cetera. And you're currently holding $800,000 in reserve funds. The FTC's receiver demands it by court order, and you have to turn them all over. What are you supposed to do? How do you manage this? So Ellen, what do you do in this circumstance?
It's a really difficult situation. A lot of processors will comply with the court order and turn it over. You have your choices are bad choices and worse choices sometimes, because what happens here is usually these cases make a big splash, so there's a lot of press about them. That drives up chargebacks. So that the chargebacks are going to come in, and here you are risking not having the money to cover them, meaning you're having to come out of pocket to pay them. But with a court order in place, it's really difficult to sort of do something differently. You could potentially legally challenge whether this money is the merchant's money to begin with, or whether it's the bank's money who's holding the reserve funds. Those challenges have been made. They're very long and expensive. Most of the time they don't go in your favor. So you have to weigh all of that in when you're deciding whether you're going to take a hard line there. In the past, and maybe even still now, but I think it was easier in the past, sometimes you could strike a deal with the receiver and the FTC to potentially keep some of the reserve funds held back in your account solely for the purposes of paying new incoming chargebacks. But, that's getting a little bit more challenging to do. That also involves, some negotiation and a lot of paperwork drawn up to do that. So it's a tough situation. And I wish I had better answers to it, but oftentimes you end up turning the reserves over. And what's can be the extra worse news on this is sometimes you turn over the reserves in a situation where the action against the merchant is very preliminary. It's a temporary restraining order and a preliminary type of an asset freeze, and you've turned the money over, and then later the court overturns the asset freeze and you want to get the money back, and you got to make sure that the receiver actually gives the money back to you and not your merchant, because then you got to go try to get the money back from the merchant. So it's not a great situation, but these are some of the things you're going to have to think about if you find yourself. And frankly, a lot of processors do. This comes up all the time. So
yeah, it is. It's definitely a common scenario. And Brian, we're not suggesting that this is a scenario that you've necessarily experienced at your institution, but we would certainly appreciate your insight into how a sponsor bank views reserves and kind of how do you manage them and these types of scenarios that may come up.
Yeah, like you say, it can be difficult sometimes, and thankfully we haven't found ourselves in this position a lot, particularly for, money the size of the hypothetical you're talking about here. And honestly, I think, the way we think about it is, sort of second line of defense in terms of recovering potential losses. And the first line is the day-to-day, settlement transactions from the merchant that we can settle up at the end of the month for losses that they take. But then their reserve is next in line. If we don't have enough to take that, then we think about that. Plus, in our business model, we use, third-party service providers, ISOs, that also maintain a reserve with us. And so if we're faced with making some of those hard choices that Ellen just described, it would be a joint discussion with our ISO, because we would be in that hunt together. And how hard do we fight? How big? What's at risk? Is the merchant likely to survive or not? All those sorts of things go into the decision about how to deal with a reserve, particularly in this sort of hypothetical that you've drawn up here.
Yeah. Brian, I just following up on something that you mentioned, since we are talking about kind of the high risk industries today, I would assume that if you're dealing with ISOs, for example, you probably have some ISOs that operate in higher risk industries that you obviously know about. Do your practices around reserves kind of differ based on the type of ISO that you're dealing with?
Not really. It's still kind of a dollars and cents calculation at the end of the day. We are certainly willing to work with ISOs if they have a good track record and the nature of their portfolio overall is such that there's some concessions or some creativity to happen there. We're always willing to listen and work with our ISOs on that. But out of the chute, it's somewhat of a formulaic approach that we build into our contracts. And if we are willing to negotiate that, it's around the fringes and not at the core.
Great, got it. That makes sense. All right, let's move on to example number 2. So here you've got a payment facilitator that boards a sub-merchant that sells CBD products. The sub-merchant processes more than $1 million annually, although the sub-merchant's application indicated that the processing volume would be less than that. The sub-merchant's business is generating a lot of complaints, BBB complaints, et cetera, and is drawing the attention of the FTC. So the FTC sends a CID, let's say, to the sponsor bank asking for information and records about the sub-merchant. I suppose that CID could be sent to the processor that's working with the payment facilitator as well. In reviewing the information to respond to the CID, you discover that the sub-merchant may be processing transactions for other merchants that sell CBD that weren't necessarily disclosed, or maybe they're selling other different types of CBD products than you were necessarily expecting or perform diligence on. So again, Ellen, I'll kick it off to you maybe to start. What do you do under this hypothetical?
Sure. Well, first of all, you have to respond in the CID unless you've got a very good reason to object to it and want to deal with that. So, you have to respond fully and honestly and provide the information that's requested. But if you, chances are if this is a one-off type of a situation, you might have discovered some things here, that are not working in your business. Maybe there's some policies that aren't being followed. Maybe there's some procedural things that didn't come into play. Maybe when that sub-merchant hit the $1 million mark, something else was supposed to happen to put them in a direct relationship with the processor that didn't happen, or maybe there's not enough monitoring going on with what the sub-merchant is doing to make sure that they're not acting as a payment facilitator and or payment facilitator, all these things. So I would use this very much as a wake-up call and maybe an internal warning, and hopefully it's not more than that, to really get your act together on this stuff and see if there's some things that you need to button up a little bit on policies and procedures and internal risk controls and those types of things.
And Brian, from your perspective, again, I'm sure that you've been involved in decisions or your team is involved in decisions sometimes about the need to terminate a merchant. And I guess I'd be curious if you could provide maybe some insight into, what are some of the things that go into that calculus and calculation when you get a scenario like this and maybe, significant red flags are raised?
Yeah, well, that's kind of two parts to that question, Andrew. We get CIDs fairly frequently. And I treat them, I treat the ones I currently get a lot differently than I treated the first one I got. And the way I treat them now is, we don't overreact. We've responded to many CIDs over the years, and you do occasionally find that email that you wish wasn't there, or you have a human error in applying a policy or stuff like that. And the regulators have followed up with us on occasion, informally, but knock on wood, nothing formally to the bank. And thankfully in our case, we've performed a lot of oversight on what we're deeming high risk merchants here. And usually we have good information to give, particularly if the merchant is on the up and up, at which in our portfolio it's unusual for them not to be, because we've kept close tabs on them. And so the short answer is I don't worry a whole lot when we get CIDs now. We respond to them, we answer them, we work with our ISO to get them done, and we send them in. And a lot of times we don't hear anything back. But in terms of terminating a merchant, I'm not aware of us terminating a merchant purely because of a CID. A lot of times we find the merchant was terminated 6 months ago, and now the CID's coming in, that sort of thing. But I myself have not been involved in a lot of merchant terminations, a few of our big ones occasionally, but that usually happens in our risk group, and it happens fairly frequently for reasons, not directly related to CIDs.
Got it. Just for typical financial or business reasons, I guess, in those cases. Yeah.
Yeah, sort of match list kind of reasons.
Sure. Got it. Okay. We'll move on to our third and last hypothetical. As you can see, they're becoming a little bit more significant each time. So now you're responding to a CID about one of your merchants that provides tech support services and provide the FTC with the underwriting file, the merchant agreement, all the different things that they asked for. And fortunately, maybe like Brian just mentioned, you terminated this merchant previously here, 3 months ago, but you did do 2 years worth of processing for this particular merchant. And you've actually had a number of CIDs from the FTC over the past year, all about merchants, maybe different merchants engaged in providing similar tech support services. So about 4 months after responding to the latest CID, you get a new CID from the FTC. But this time, it's not the customer that seems to be the target, but more your company that is the target. So it could be the processor or maybe the payment facilitator or the ISO, for example. And the FTC wants to see your client list. They want to look at your underwriting and risk management policies, review company emails, documents, everything, even interview key employees. So Ellen, how do you respond to this scenario?
Okay, well, so the first thing I think you're going to need to do is make sure you preserve all of your documents and evidence, and make sure that everything stays in place. And then secondly, you're going to need to find a good lawyer to help you through this, because these are really significant situations. This is different than sort of you got that one-off CID that we were speaking about a moment ago. Here, they've kind of piled up a little bit. You've seen a few of them, might even be more than 4. I think 4 is still maybe a lower number there, but we know some processors receive lots of them, and they're all sort of in the same zone. So it's really going to cause a regulator to think, are you some sort of a gatekeeper for this industry, a high risk industry, allowing them to get processing without really being very careful in what you're doing. So it's a little bit of everything that we've talked about. You're gonna of course need to respond. You're going to want to most of the time on CIDs, a lot of the requests are overly broad and they're confusing, and they don't really they're not really written in a way to get your business. So you're going to want to work closely, get counsel, work closely with the FTC to figure this out. But in the meantime, you're going to want to also look and see if there's any sort of immediate remediation you need to try to do. Do you have enough staff in the underwriting department to look at this? Are they trained well enough? Are there things that you can do to show in earnest that you actually are concerned about this? Maybe you've got a story behind each of these, and they could be quite legitimate and valid, and so you just find yourself explaining it. But this is how sometimes we see some of these types of cases against processors evolve, and it's one of the reasons why you want to be so careful about risk management and policies and procedures to begin with.
Yeah. And Brian, I guess from the sponsor bank perspective, we talked a little bit about when the bank receives a CID asking for information, but do you, as a sponsor bank, do you know when your ISOs or other kind of sponsored entities are receiving CIDs? And, how do you, if you do know and you find out, how do you kind of oversee or think about that process?
Yeah, we typically, I have not found out if our ISOs are getting CIDs directly from FTC or others. They may be calling our client services reps or our merchant department management to work through that. But I've not been made aware of those happening with us. And, thankfully, I think the bank has not found itself, being the target of a CID. I think the FTC would probably rely on our prudential regulators to deal with us if they wanted to escalate it. If that happened, we would cooperate fully and do our normal thing that we do with our regulators, which we try very hard to maintain good relationships with. We had one situation a while back where we were in the middle of litigation with an ISO that became the subject of a CID. And so, where I normally would handle a CID in-house about that, I did turn it over to outside counsel because of, we were in hot litigation with the subject of the CID, and I didn't want to, get wires crossed, giving confidential info to the wrong people and all that sort of stuff. So, other than that, we have had some complications, but they've been rare, thankfully.
That's great. And one other, a point I think is just worth mentioning here, because we do see this come up. There are obviously payments companies that are based outside of the United States. And, sometimes I think this is, completely legitimate. Other times, maybe it's an entity trying to find a way to evade scrutiny in terms of its activities. But I think it's just, an important reminder that as a general matter, if you're providing services to U.S. merchants, if you're facilitating the sale of goods and services to U.S. consumers, there's very likely going to be a hook for law enforcement to be able to bring an action and to investigate you. And so, simply being located overseas is not a way to get out of this type of scrutiny and activities. Not just from the enforcement perspective, but even in terms of settlement and ultimately. Whether you can protect assets or not. So just an important kind of consideration to keep in mind. All right. Just quickly want to run through as kind of a reminder for the audience, or what are some of the red flags in payment processing that typically will draw scrutiny or that law enforcement will look at more closely. Credit card laundering is certainly at the top of the list, where you have a merchant processing transactions for an undisclosed other merchant. That's a significant issue that is always being looked at very carefully. Any making of false statements to a bank to obtain payment processing services or to disguise or hide payment processing services is a huge red flag. It can also be a criminal violation under federal law. Failing to disclose, material information about a merchant account, including, the owners, who the actual owners are, the true beneficial owners. Any connection or control that's being exerted by someone that maybe was previously terminated and is on the match list, for example. Those are red flags. Similarly, using a shell company or straw nominee owners to kind of apply for and receive multiple merchant accounts. And finally, using tactics to try to avoid the card network or the sponsor bank or processor risk monitoring programs. Things like load balancing, where you're moving transactions between different accounts to manage chargebacks, and splitting a single sales transaction into multiple smaller transactions. These types of activities will draw a lot of scrutiny from regulators, and likewise are things that accordingly, sponsor banks and processors are going to be on the lookout for as well. We have just a couple of recent enforcement actions here that we can kind of run through. The first one, Brightspeed Solutions, versus it was a CFPB enforcement action. We included this one here because it shows that the CFPB is back into looking at payments companies. There really hadn't been much of this during the prior administration, but now I think it's something you can expect. Here it was a payments company using remotely created checks, payments in connection with an internet-based technical support service that the CFPB alleged was fraudulent. And so that I think is something important to keep in mind. It's not just the FTC. We've seen the CFPB in the past. We've seen the Department of Justice and even state attorneys general bring actions. Electronic payment solutions. This is the most recent settlement just happened earlier this year, but this is a case that's been going on for many years with different defendants that have kind of settled at different times. And so I think it's a good reminder that if you find yourself in an enforcement action context, these cases last a really long time, going through the investigation process to the settlement process to negotiating a stipulated agreement, et cetera. And it can take a really long time and cost a lot of time and effort to work your way through conclusion. And finally, another recent FTC case here, Complete Merchant Services, which was, again, the FTC just raising a lot of the red flags that we talked about on the prior page, right? High rates of chargebacks, use of multiple accounts to try to evade detection, et cetera. So there's more there each year. There's more enforcement actions. This is just kind of a sampling that we thought was worth discussing. The other recent development that's worth touching on is the recent Supreme Court decision that has impacted the FTC's authority, at least in the near term, the case of AMG Capital Management versus the FTC. So for many years, really, I think going back to the 1970s, the FTC has taken the position that under Section 13B of the FTC Act, which is its authorization act, that the FTC could bring suit in federal district court and seek an injunction against those that it believed were violating or about to violate the FTC Act. And they would basically bring these actions to get an injunction, and then they would seek monetary redress, disgorgement, for example. And this was really one of the quickest and easiest ways for the FTC to bring an action. And according to the Supreme Court case, they have some statistics in there. In 2019, for example, the FTC had filed 49 complaints in district court and gotten, I guess, in total 81 different permanent injunctions. And that compared to just 21 actions that the FTC brought under its own administrative process. So this is really a tool that the FTC was using a lot. They've used it in a number of the enforcement actions against payments companies. But the Supreme Court said not so fast. This authority under Section 13B can only be used when you reasonably believe that a defendant is violating or about to violate law. It can't be used to go after somebody based on violations that happened in the past, which is really what the FTC was doing. If they found a payments company, for example, that had done something unlawful in the past or that they thought had, they would use this action as their hook. But the Supreme Court says, no, this is really about forward-looking conduct. And then secondly, this particular statutory provision doesn't authorize monetary relief. So in the short term, this is going to impact the FTC's enforcement, but I think it most likely will only be in the short term. The FTC has other tools that it can call on. As I mentioned, they have the ability to bring administrative litigation cases. They can refer cases to the CFPB, to the Department of Justice, like Brian mentioned. they can refer them to the prudential banking regulators. And so there are definitely other tools that they have, including currently working with Congress to see if they can find a way to restore this authority by law. So Ellen, I don't know if you have any other kind of thoughts on this case.
I think we expect that there will be some replacement authority given to the FTC, granted to the FTC by Congress at some point. It could be by the end of the summer. I know that there's a rush on the FTC's part to get this problem fixed, so to speak. They think that, consumers are not protected unless they get this type of authority to go back and sort of punish past conduct. The other thing about past conduct to be aware of, and we think about this with payment processors a lot, is if you've terminated the merchant and wrap things up with the merchant, if the FTC comes later because of your actions, well, it's a really easy argument to say, well, look, I'm not violating or about to violate the law by facilitating the merchant's processing because I've terminated them. But there's potentially arguments the FTC would have that, well, your past conduct actually is an indication that in the future you might be likely to board other types of merchants like this and do just as bad a job of monitoring it and underwriting it and all these types of things. So, I'm not so sure yet how this past conduct type of thing might play out. There could be some implications there. And then the other thing for payment processors is to be aware of is, notwithstanding this 13B stuff, the ability of the FTC to go and enforce a rule violation is still there. And under the telemarketing sales rule, which would be used in almost every telemarketing case, there is this provision that makes it unlawful for somebody to provide substantial assistance to a party who is violating the telemarketing sales rule. So that can encompass a payment processor directly, a payment processor who provided substantial assistance or support to the merchant and sort of turn a blind eye to red flags that this merchant might have been violating the telemarketing sales rule, which in itself prohibits fraudulent sales calls and things like that. So it's not, it was a good victory, so to speak, but definitely we need to proceed with caution there. And how about the CLE code?
Oh yeah, perfect timing. So the CLE code for this session is Payments 2021. So Payments 2021.
All
right. So now we'd like to switch to talking about specific kind of higher risk industries. We'll spend a little time kind of explaining, what they are, what some of the risks are, maybe, some of the compliance considerations for each as well. And why don't we start, Ellen, if you could give us kind of an overview of the tech repair industry.
Okay, so this is what I think I'd pay attention to if you have merchants here. Andrew just mentioned the Brightspeed case. There's an example FTC case we put here, but there's others. And these are really, often an elderly person is duped into these things. They are, maybe they're calling to get like a password recovery done. And they find a service, and then the service gets in there and says, we need to run diagnostics and we need to look into your computer. And of course, oh, you've got viruses everywhere, and now you should pay us on a monthly basis to clean your computer and help protect you and all these sorts of things. And so there's telemarketing components often involved here. There's online selling components. There's often a subscription-based marketing component, which we're going to touch on briefly in a second. But all of these things sort of spell kind of a higher risk type of a merchant. So we don't need to dwell on it, but it is one that I would pay attention to if this is in your sort of accepted list.
Next topic would be mobile gaming. This is also for you, Ellen.
Okay, so mobile gaming, I think I read, and this might have come from something the FTC wrote, but it's a $70 billion industry, probably growing. And to be clear, we're distinguishing this from gambling gaming. Mac actually did, our co-sponsor for this event, Mac did a nice webinar back in May that is available to Mac members. So if you're a Mac member, or if you need to become one, go back and look at the webinar from May on gaming, meaning gambling, but here we're talking about mobile gaming, and sort of platforms that will facilitate game developers and gamers who like to play these games. And there's all sorts of things going on there. This was a case that the FTC featured and earlier this year against, I think the company was Tapjoy. They were sort of that middleman sitting there, sort of connecting gamers with developers. And they also ran a lot of advertising and would promise gamers that, hey, if you watch these ads, or if you, do some of these other actions, you can get in-app rewards to use at these other game sites, and just never, that all kind of just fell through the cracks. It never really happened. So says the FTC. And the FTC took a pretty hard line on this. The two, there's what we put up here was the statement that these two, the commissioner and the chairman, new chairman now, I guess, Kelly Slaughter, interim chairman, issued about it. And they took a really hard line with this. I mean, they described this particular defendant, Tapjoy, as sort of a minnow, where I wrote it, a minnow next to gatekeeping giants who are facilitating this terrible conduct. And they're really spotlighting this to go after sort of bigger fish in the sea. Middlemen is a big issue. Payment processors are middlemen, so we've been talking about them as middlemen, but even there, I think this is one to really pay attention to and watch out for.
Yeah, and I would just say, I think, what Ellen's talking about are kind of some of the consumer protection issues. I think in terms of how payments companies think about this in compliance, when it comes to mobile gaming, there can also be, money transmission related issues as well. If you're talking about games that allow for loading of funds into the game and then later being able to cash them out, things like that. So if you're involved in this area, that's certainly something to keep in mind too when it comes to your diligence in underwriting.
Hey, Ellen and Andrew, let me just add something quick before you move on. And that is, I'm glad you made the distinction between gaming, gambling. I think we've looked at all those. We do some of those, but right out of the chute, it's important to distinguish those. And then you throw in fantasy sports and some of those other sorts of gaming-like, gambling-like sort of industries. For us anyway, the analysis is similar in some respects, but very different in other respects. So if that's a business that you want to work on and you want to convince your acquiring bank to do, just make sure that those distinctions are clear, as you approach those businesses.
Yeah. And even just to build on that really great point, Brian, is that for all of these verticals that we're talking about, but specifically, I think here, right, you need to have policies and procedures and your own understanding that is tailored for the particular vertical that you're talking about, right? I mean, most processors and sponsor banks may have a general underwriting approach that they take for kind of plain standard merchants. But when we're getting into these higher risk verticals, you really have to be very thoughtful in terms of how are you underwriting them? Do you understand their business? And then how are you kind of managing them moving forward? And to your point, you really do need to understand it because there can be important differences depending on what exactly is being done. So that's a great point. We've also got here, COVID related products and services continue to be the focus of law enforcement. The Department of Justice has been bringing a lot of enforcement actions against fraudulent companies, selling products or services involving, COVID cures, things like that. The FTC has issued hundreds of warnings, and the CFPB is also, really focused on this. And, Brian, I guess I'd like to kind of maybe get your perspective a little bit, because this is, as opposed to some of the other high-risk verticals, this is something that kind of came out of nowhere in terms of, the pandemic and created a lot of challenges. So, how would you, say that a bank or really any company, can manage these kinds of unexpected higher risk areas that may pop up?
Yeah, it like everybody in the world, it was all hands on deck there for us for several months. Both in terms of, looking out for these sorts of merchants being cute sorts of stuff, which, because of our our past high risk business, we had lots of monitoring tools in place, lots of sort of processes and policies and things that we really just turned the knob up a little bit, from what I understand from our underwriting folks, and that is, with some continuity merchants, some of these opt-in programs, which a lot of these COVID schemes were sold using those sorts of, I'll say old school, new school products through old school methodology. And we just, like I say, sort of turned up our observation capacity during that time. So we had the merchant, that sort of scamminess happen on one side, which I think our guys dealt with very well. But then we also had, merchants struggling, summer camps and, hotels and restaurants, and our ISOs that focused in on some of those verticals. So we had programs, and, we scrambled, like I say, all hands on deck for a couple of months to put some programs together to kind of, cushion the fall to the extent we could. And I think those programs were very successful as well. So there you go. That's sort of our experience on COVID.
Great. And one of the things you mentioned leads well into the next topic, using recurring billing or subscription type models as a sales tactic. And that's certainly another area of risk. Ellen, could you maybe give us an overview of this?
Yeah, and I'll be quick here in the interest of time, but this is, we've been talking about this forever. So there's still, all the laws are there. Here, I mentioned the telemarketing sales rule again, because that's going to be a rule violation, not a 13B, as we were talking earlier. There's state laws involved. A lot of these higher risk programs and COVID products, cleaning products, whatever it is, are being sold on subscriptions. And so just something extra careful there, not just the claims that somebody might be making, a merchant might be making about this product, but the way that they're selling it and who they're targeting for it, all kind of factors into the consumer risk of loss that you'd have to take a look at.
We have cryptocurrency here. Again, I think we can kind of hit this just really quickly. It's an area that's gaining traction, and I would not be surprised if a lot of sponsors or processors are getting, requests for processing services from cryptocurrency exchanges or companies that are seeking to facilitate payments through cryptocurrency. Now you can buy, non-fungible tokens, NFTs online. So definitely an area that's growing. It is, higher risk. The FTC, CFPB, and others have issued kind of warnings about some of the risks involved, at least in investing in cryptocurrency. And cryptocurrency, at least exchanges and certain other companies, are likely to be money services businesses, which are already higher risk as well. So I would just flag that as kind of an area to keep in mind moving forward. I think we'll move on to the next slide in the interest of time, which is CBD, which has gotten a lot of attention over the last year or two. And it continues to have, I think, a complicated legal framework. Sometimes people may try to simplify it, but it's definitely not simple. So, hemp under the Farm Bill was removed from the definition of marijuana, which is illegal under the Controlled Substances Act. And so CBD derived from hemp is no longer necessarily unlawful under the Controlled Substances Act. But there are still FDA related rules and regulations that are relevant in terms of whether it's being marketed as a dietary supplement or food. There's state licensing frameworks that have been set up, and there's certainly a lot of FDA and FTC scrutiny around merchants marketing CBD products and kind of the claims that they're making. And so Brian, for you, I guess, how do you think about, how does a bank kind of manage an industry that sits at the intersection of some of these different legal frameworks, federal law, state law, et cetera?
Yeah, it's difficult. CBD, Merrick has recently, started allowing CBD sales. But the basic stance we've taken is, as long as it's illegal federally, we're not really interested. For a lot of practical reasons, as well as legal and risk reasons. The first practical reason is, that we can't find a MCC code that Visa has issued for the stuff that's still federally illegal. So, very practical reason that we just can't do that. So yeah, it's a challenge, and we've sort of taken a lot of, I'll call them overlays from, tobacco and alcohol and some of those other products that have certain state law requirements. And so we've sort of torn a page from those books and overlaid it over to some extent in our CBD business as well.
Yeah. And I think, we've worked in that area as well. And I think some of those overlays that you're probably thinking about are, making sure that the seller is licensed if they're required to be licensed under kind of the state hemp framework, getting lab results that show that the products that are being sold actually have the THC level under the limit, maybe getting legal opinion letters and different activities like that in terms of managing that risk. And you're definitely right that, marijuana remains illegal under, the Federal Controlled Substances Act. And, it's unclear whether it's going to remain that way. More and more states have been legalizing it. Congress continues to look at some different legislation about either providing a safe harbor for banks or maybe legalizing it. But, so far it still remains kind of unknown, but it certainly hasn't stopped different companies from trying to find solutions in order to facilitate kind of non-cash payments at dispensaries. So that also continues to be an area for focus.
Hey, Andrew, there's a question in the Q&A about cannabis, and
Okay.
I'll take a crack at it. There's been a lot of proposed acts. The question mentions the MORE Act. We follow those, we watch them, but it's almost, crying wolf again. Like I say, there's only one portion of the risk in cannabis is legal. The others are very practical of, how do you sell it? How do you, how does your merchant open up a checking account that you can deposit things into, those sorts of things. And so, if the MORE Act does it, then we'll be in. If it doesn't, then, we'll keep watching and, waiting, and it'll happen someday, but I don't think it'll be tomorrow.
Yeah, no, that makes a lot of sense. Adults is another kind of high risk that we wanted to talk about. It's obviously gotten a lot of media scrutiny. We know that MasterCard has come up with some updated rules around processing for adult content. And we've got these up here on the slide for those that are interested. But Brian, I guess my question for you is, how does a sponsor bank deal with areas where there can be significant media pressure, and maybe even more broadly? I mean, is reputation risk something that banks actually do focus on?
Absolutely. Reputation risk, is one of the 5 areas that our regulators even examine us on. And the challenge there is, determining ahead of time what you want your reputation to be and how you want that reputation to move over time. Because at least folks in this bank, in my bank, have different thinking about that, particularly when it comes to some of these merchants like adult or gambling or marijuana. So the first step is, what do you want your reputation to be, and then you manage backward from there. At least with us, I think our reputation is one that we want to be known as accepting legal businesses, that are willing to pay for our processing services. And so we've established the tools and the processes to sort of manage that reputation risk as well. And, it's a process. It's not an event.
Yeah, exactly. And an ongoing process, right? Subject to evolution and updates, et cetera. So the last vertical we have here is one for Ellen to discuss, multi-level marketing.
And I promise I won't read all this, but multi-level marketing, there's a lot of them out there. There's more and more cropping up every day. We get asked a lot, both by MLMs and then by processors, to sort of evaluate their programs, and a lot of times they're sort of their recruiting programs and their downlines and the compensation structure and all those types of things. And this is a really challenging area. And I gotta say, we see so many FTC cases here, and we've even seen challenges to the FTC from people who run multi-level marketing companies saying that, the FTC is potentially overreaching and what it might be deemed as being sort of an unlawful multi-level marketing scheme. But these are hard to evaluate. I do think you have to dig in very deeply. A lot of times we'll just see like a lawyer letter from the MLM's attorney, and they're very surface level. They're very hard to rely on. If you're going to do this and you want to dig in and really know what they're doing, you're going to have to dig in and really ask for a lot of information from the MLM and really figure this out to make sure it's all set for you. So we can probably keep moving because we're running real short.
Yeah, so we've got just a few minutes here. We'll kind of close on talking about some compliance best practices. And obviously, it starts with having a general kind of compliance management system in place, which will be based on your AML obligations, card brand requirements, and other kind of relevant consumer protection concerns. But I think, a big part of it, at least what we've seen some of the regulatory focus on recently, are managing your third parties, whether they're ISOs or sales agents, et cetera. And, there's been FTC enforcement action recently, really providing some feedback on what ISO oversight might look like. We've got some of those up there on the screen for you. But Brian, when the FTC or another regulator comes out with something that maybe suggests new best practices, how do you think about that? And do you kind of monitor these things to look for ways to update your own internal programs?
Absolutely. And I'll say, all of the prudential regulators have very precise guidelines over managing third parties. And so they pay attention, and we also, have crawlers, and we watch for these decisions, and we review them closely when they come out to make sure that, we're up with the latest.
Yeah. Merchant underwriting and monitoring. I mean, we've talked a lot during the presentation about looking for red flags. And, a lot of this has to be something that I think is built into your underlying kind of onboarding procedures and how they're set up. Are you actually capturing the information that you need to look for these types of red flags? But there's also certainly a lot of, third-party resources that are out there as well. And Brian, I know you had mentioned briefly, I think in one of your earlier answers, leveraging kind of third-party resources, software vendors, et cetera. I don't know if you have any thoughts about that, if this is kind of a helpful model and like some of the future maybe moving forward.
Yeah, no, you're right. And I will say, I agree. In the interest of time, we do use third parties. We have a vetting process. It's very formal. Again, those parties are third parties to us. So we have to, make sure we understand what they do and how they do it. But we absolutely rely on some of those folks to help monitor our portfolio for sure.
All right. And then lastly, Ellen, what's the role of kind of merchant agreements when it comes to compliance and other kind of risk management issues?
Yeah, I mean, I would say that if a lot of us use standard merchant agreements, but if you're in the higher risk space, you might need a different type of agreement for your higher risk merchants. You might really want to focus in on how you're defining what they do. You think about things like excessive processing. What's your remedy going to be? Because so many of these merchants will actually exceed the processing estimations that they put on their application. So what do you want to do in those situations? Or how heavy-handed do you want to be in terms of financial remedies if they do some act that you deem to be in default, and that may be engaging in some sort of harmful, consumer harmful act or practice. So rethink all these things. These things get challenging too, because there are actually a lot of court decisions about enforceability of certain contract provisions and financial penalties and all those types of things. So this is another area where it pays attention to, you need to pay attention to it. It's something you want to do. The last thing I'll say is also, you might also want to revisit your sales agent agreements. I mean, a lot of them are independent contractors, so you can only do so much, but to the extent that those are, you have contracts there too, I think in the higher risk space, these really need some unique attention.
Great. And there was just one other question, I guess, that came in that's worth touching on, which is it appropriate to require your ISO to disclose when they receive a CID? And that is certainly a type of provision that we will see in agreements, requiring disclosure of CIDs that are received so that a bank will be knowledgeable about it. Now, there may be circumstances in which the regulators or the law enforcement agency will, suggest that it's confidential or it can't be disclosed, and so those are issues that need to be worked through and thought through. But it is something that is included oftentimes in agreements. And so with that,
I would say, Andrew, that it might be a good thing to disclose it, right? I mean, keep the relationship open and honest. I'd rather find out about an ISO getting a CID today than 6 months from now when I learn about it, otherwise.
Absolutely. So those are great final words and guidance, I think, to close out the presentation. So thank you to Brian for joining. Thank you to Mac for helping to sponsor this event. And just to remind everyone that we have our third and final panel on kind of developing payment concepts and models tomorrow at 2 p.m. Eastern as well. So thank you everyone for joining.